The video's title will be referencing something current, of note, public interest, and more importantly, this is not medical misinformation. Here we go. 1790 to 1835, the maximum term of validity for a patent or copyright. We're talking about one of the two. It's sort of a quiz question. 14 years from issuance. Patent Act of 1790, but patents and copyrights have a lot of similarities. 36 to 1860, 20 years from issuance, or actually 21. Now, currently it's 20 years, and that seems reasonable by most people's standards modern, but this was done in 1830s, and that was the Patent Act of 1836. Then it was changed to 17 years from issuance, and then we have a very stereotypical American legalese version. Instead of calling it the Patent Act of whatever, it's from 1861 to 1994. So this is for patents. Then it was from 1995 to 2021, 20 years from filing. The Uruguay Round Agreements Act, again, a very stereotypical American name that doesn't tell you really anything about when it was done or why, or what even effect. But it's Agreements Act. Films previously in public domain were now copyrighted again to make them in line with retroactively changing the patent timing. But that's for film, isn't that copyright? Depending on what you're doing, you can be forced to defend your case in court or not have to unless you want to, depending on if it's a copyright or patent or trademark or whatever. Certain things must be defended aggressively, otherwise you're acknowledging you don't wish to defend them. Things that are abandoned are not owned by you. Now, 1928, Disney's Mickey Mouse copyright will stop in the year 2024 until Disney does yet another attempt to extend copyrights for all of us, for our benefit, so that they could be a multi-billion-dollar company, or whatever it is these days, and get away with it. This is caused by, originally, them doing yet another extension to their copyrights by getting laws passed that benefit them and do not benefit us for another 20 stinking years due to illegal copyright extension rule changes. Dates that copyright duration in years had changed. 1790, 14 years, you could renew it another 14 years, 28 years maximum, after which you had to give up control over your copywritten work. Book, magazine, maps, all sorts of things. It is based on things not having any permanence, but also based on you having a monopoly. You have a monopoly over something you patent or copyright for a specific number of years, and you're not allowed to extend it. Well, then you were, because money talks. 1831, 28 years, literally double, with a 14-year renewal, 42 years total. Then it was 28 years and 28-year renewal, so 56 years total, in 1909, making it the practical upper limit from an adult age at 76 if you created a work when you were 20 or afterwards, till the age of 76. That was the idea. That's where this comes from. The total number of years if you were willing to file a copyright or patent, copyright in this case, and then do one more renewal before it ended. This allowed you, if you wanted to keep exploiting it, if it could be shown at the time, this was the argument in 1909, that it was still giving you money, that you were still making money on it. If you made a book and people were still buying it 28 years after you wrote it, when you just out of college, when you're like nearly 50, yeah, that makes some sense. Obviously, if there's a market for it, you don't want the copyright dying when it suddenly became popular when people thought you died. The joke is it always becomes more valuable when you drop dead. So you could, put some music together that's an imitation of the Doors, wait till it becomes popular, and then, and then get your copyright money. You've all seen this. An old song becomes popular for no damn reason. This is actually where it came from. In 1909, books became popular because books stopped rotting as often. Books were more mass-produced and using pulp, but they still lasted 20 to 50 years, and people would want to have the books, and someone might undercut you by printing your own copies of your own work. 1976, an individual author's lifetime plus another 50 years was the standard because of this phenomena. But why would you? Well, that's so your children can inherit. Okay, that seems okay, but Wait a minute. This was done at the behest of Walt Disney Studios, wasn't it? Yes, it was. This has nothing to do with you or me, our benefit, and it's litigiously graded. It granted retroactive extension for corporations. So that doesn't benefit you and me. That means that corporations can slap you with a copyright violation. Yes, I'm on YouTube, and this actually pisses me off because this has actually been used against me and thrown out, which is weird. But anyway, let's go on. 1998, 20 more years added. The Sonny Bono Copyright Term Extension Act. No, it's called the Mickey Mouse Patent Law, or the Disney Studios demand. And then the year 2000, 100 years thereabouts for any corporation, or 70 years after an author's death if it's a human, because corporations which don't have any rights want them, including the right eventually to vote by proxy. No, they don't. But think of it. What would stop a corporation from saying all of our shareholders have a right to have us vote for them? You can sign off your vote. I'm sure that that's acceptable someplace. But that was only for works from 1978 forward that were already under copyright under these other extensions, so they could try to extend it a lot further. So it's 100 years past creation. So a 1928 Disney Mickey Mouse copyright would stop in 2028, but it wasn't acceptable. So it was 70 years past the author's death, and again, that didn't work. So Disney can't extend it unless, of course, they do just what they did the last time. Now, why am I bringing this up about a video about Moderna? Moderna has not previously brought any product to market that got a patent or whatever, apparently. Moderna received nearly $10 billion of taxpayer funding to do the following: develop the vaccine, test it, provide doses to the federal government. And we had an agreement with them. Moderna has already lined up a lot of money to be able to be made on this. Billions, 35 billion, through the end of 2022. Has made limited efforts to get its vaccine to poorer countries and doesn't want to. Obvious financial drive. They have no plans to share the mRNA technology, recipe, formula, or anything else for specifically one vaccine. And again, this patent originally started off 10 years ago being created. They were creating the technology and developing it. So they have 10 years into this. But really, no one cares about it until COVID-19 comes across. The idea was to make, this is the original idea, is to find a way to make a kind of vaccine that doesn't require that you ever even touch the disease. Completely isolating the virus or bacteria or fungus or parasite or whatever, so that you could make an immune system respond to something without ever having any possibility of a contamination because the virus is never there. Also making it to where you don't have to use any preservation methods that would involve anything even marginally dangerous, much less toxic or carcinogenic. This would make it to where it would, if anti-vax people were being honest, anti-vax compliant, because they made demands like that a long time ago. And suddenly this comes up. This is like 10 years ago. But for the last 4 years, the U.S. government also, not only doing all these billions of dollars worth of help and making sure that they got, waivers so that they could do it because it's an emergency. And we, the people, decided to do this through our representative government. 4 years ago, they had 3 collaborators from the National Institutes of Health assist in creating these things. And Moderna scientists were the only ones listed in the patent that was filed in July this year. Now, if the U.S. government gets away with slapping them upside of the head with a big fish because, yes, this is a way to cut us out of it, do we get the billions of dollars back plus interest? Do the American people have an absolute right to it because yada yada? Now, for 10 years worth of work, they didn't make any progress. I mean, none of you heard of it. I'm sure they did, but I'm sure they have some patents, right? Anyway, the federal government could have more say in what companies manufacture the vaccine, and more accurately, not letting it be restricted so more companies can make it. So Moderna has to compete using their own patent with other companies, which violates the whole point of a patent. But it would be licensed. They get money for licensing. That's how Microsoft made all its billions of dollars. They never really sold anything. They licensed it. It's different. The U.S. government would be able to influence which countries get access. Translation, making sure poor people get it. It is not in your best interest that anybody on this planet still has COVID-19 in their system. It's not in your best interest. Getting rid of this, making sure that everybody can get vaccinated, is in everybody's best interest. Well, that sounds like socialism. You're going to hear that from people, especially people who are investing in Moderna. Big pharma assholes. Yeah, it's socialist to make sure that their patent is ignored. Also, the federal government would get millions of dollars per year out of it because they get, by definition, they had an agreement where they get a tiny amount of it going back to the National Institutes of Health because the U.S. government and the National Institutes of Health made it to where this thing actually finished happening. Also, the U.S. government takes a hit here because we all, in effect, when we did our first dosages before it was completely approved, we were all part of the world's, maybe the world's largest ever medical test, maybe the world's largest comprehensive round of real-world testing for a medication. So it doesn't take 10 years. It can take 1 year. And we should use this as a precedent if needed. It's somewhere or other, it had a little notice that says you're agreeing to this because you are. And we all are aware of that. The Patent Office's role is simply to determine whether a patent is warranted or is unique. But then again, they used to have a rule that says you couldn't make a patent, which seems to give legitimacy to everything, for a perpetual motion machine unless you provided proof it worked. They don't require that anymore. Because corporate, Republican, greedy asshole behavior, yes, I'm going to call it that, or liberals, don't step on my happiness mode, step on your sunshine, it's a turd, both sides wanted to remove these restrictions because, well, it's stifling me and blah, blah, blah. It also made it to where it was easier to do a scam. Out of fear of potential lawsuits, Moderna is now trying to invalidate somebody else's patents because they want to have monopoly. This has nothing to do with right or wrong. This has to do with monopoly status. This is big government trying to fight a monopoly. Moderna made a deal. They are Beelzebub, but they made a deal with the devil, the U.S. government, and the European Union, everywhere else, that they were going to get access to the largest medical trial on the planet, the entire country of the United States. Everybody could volunteer if they were high likelihood to survive and be able to do the testing. And the U.S. government put aside rules and regulations and 10-year minimum durations because it's an emergency. Okay, that's reasonable. I'm going to say that's reasonable. I'm going to say that's warranted. And it is not in anybody's best interest, again, for anybody poor not being able to afford this. Have you seen Big Pharma lately make it to where any medication you want to get is jacked up 300% because it's what the market will bear? Your life depends on them getting money. Do you know all the treatments that were supposed to be patent released because they're 20-year patent? None of them ever got longer than 20 or 21 years. All those patents are dead for, let's say, fixing your appendix or whatever, or pancreas or whatever. But the companies keep putting out slightly different variations of their patents so they can keep you from making anything similar. Oh, you can get something to keep you alive that you have to take, insulin every fucking day, but we're going to make sure you die because you didn't pay us. Yes, the U.S. Patent Office, just like the Copyright Office dealing with Walt Disney, has to, by default, grant. But the point of this is the social contract or the antisocial contract. Patents are requiring a level of social responsibility out of corporations or individuals that they do not use it as a blunt instrument to do harm of any kind. It is in the interest of the commons that a movie or a medication become open source, that it become public domain, that it become something we can have access to. And this is stopped at every opportunity by greedy fuckers. Moderna should not be allowed to have a copyright or patent for anything for the next 10 years in punishment. They can live off of this because they've semaphored that they will sue everybody into the ground to keep their monopoly, even if they don't need it. They also made a pledge they wouldn't sue anybody for making any other coronavirus treatment. That would not be legal for them to do it. They promised not to do vexatious litigation. Making a coronavirus vaccine during the pandemic. How mighty pharma of you. By definition, we should punish them. You can have the patent, but you can't enforce it. Or just don't let them have the patent. The U.S. Patent Office was at one time allowed to refuse to do these things, and should do it in this case. No, it's not a sign that the U.S. government is doing something evil. It's Moderna. Thanks for watching. Have a good day. Good luck with that. And yeah, fuck.